Hi everyone, a very warm welcome. I'm Prerna Jain and it's pleasure to have you all with us for Winpe Women on Board knowledge session. So thank you so much for taking the time to join us today. For those of you who don't know us, the Winpe is a leading platform committed to advancing gender diversity and leadership representation in the investing ecosystem. Winpe collaborates closely with the private equity and venture capital firms as well as broader industry stakeholders to foster a more inclusive and equitable environment for women professionals across the investing landscape. Our Women on Board initiative partner with progressive companies to build stronger, more diverse boardroom by increasing the representation of highly qualified board-ready women leaders. The initiative provides access to a curated pool of exceptional candidate, board readiness resources, and engagement models that align with companies' governance tools, and DEI commitments. If you are not already a part of our network, I invite you to join our WhatsApp group.
नया बस ना ये मैंने सॉक्स वाली जगह पे रखा था तो वहां पे उसमें कुछ ब्लैक ब्लैक पड़ा
And
हुआ था
our repository of
I
profile
don't
that we share in
have इसे तो
anonymous
मैंने अलग ही
manner
निकाल के रख दिया था
with firm seeking board
मेरे
members.
बेड के ऊपर डाल
I'm sharing the link in the meeting chat box to join our repository and WhatsApp group. So today the topic of today's session is Digital Personal Data Protection Act, board level perspectives, a defining regulation reshaping how organizations approach data governance, accountability, and risk oversight. The session is designed for senior women leader and board professionals to examine the strategic implication of the DPDP Act. It highlights new responsibility around the personal data, stewardship, key governance constitution, and how board can strengthen oversight of data protection and compliance in an increasingly complex regulatory and digital environment. So we are delighted to have our faculty, Vanna Pai and Karnika Vallabh, with us today. Vanna, senior partner at Bharucha and Partners, is a leading private equity lawyer with over 2 decades of experience in merger and acquisition and also serve as a board member at the Birla Estate. Karnika Vallabh, a legal counsel at the Bharucha and Partners, specializing in compliances and IT laws. So welcome Vanna and Karnika. Over to you.
Thanks, Prerna. Everyone, pleasure to be here. And I think I wanted to thank Winpe for creating this forum where we can actually, have these meaningful discussions and hopefully learn from each other. So thank you, Prerna and Tina. Prerna has given you a background of, why we thought the DPDPA would be relevant for, all of us as potential board already who are serving on the board or could be potential board members. But I think one of the things I just want to mention is that I think there's been a fundamental shift in the way the law looks at it. The law now assumes that companies are in a position to really be able to respond on how their data privacy policies are. And it is very likely that all of you as board members, regulators could ask you, what did the board know? What did the board actually ask? And how was the board monitoring it? So I think for us, we'd like to keep this as something that's practical, that you can take away practical insights from. All of you have had like massive experience, so please feel free to chime in at any point if there's something that you've experienced that you want to add to what we're saying, or if you have any questions. I know Prerna has also kept time at the end of the session, but we would like this to be as interactive as possible. On which note, Karnika, why don't we jump straight in and.
Thank you, Vanna. Nandini, can we share the presentation, please, now? So as Vanna said, I'll walk you through the DPDP and particularly what the board should keep in mind when addressing portfolio companies. We can move on to the first slide, please. If you have questions, you can type them in real time in the chat and we'll address them at the end together. So the first thing we need to understand is that I hope I'm audible. The first thing we need to understand that the DPDPA is the principal legislation which governs informational privacy in India, but it is not the only legislation we need to keep in mind when we are serving on a board. Depending on the nature of your company, other regulations will apply because the structuring of privacy legislation in India is very, very horizontal. There are multiple legislations we need to keep in mind. The first is the Information Technology Act, which is your parent act, which deals with all electronic transactions that occur in or out of India. The second set of legislation is the SPDI rules of 2011. After 2027, once the DPDPA comes fully in force, we expect these rules to become obsolete. But as on date, they are relevant. The third set is the Indian Computer Emergency Response Team directions, which require you to report any data breach in any company to the CERTIN, which is an authority established under the IT Act, within 6 hours. These will remain in place even after the DPDPA comes to force. So these are parallel obligations we need to look at. And then, of course, we have the DPDPA, which is the parent legislation which will now govern informational privacy in India. Next slide, please. Apart from these legislations which apply across the board, there are certain sector-specific regulations that govern data. Based on the nature of company you are dealing with and the regulator that governs those company, that nature of entities, you may be looking at sectoral compliances for broadcasters under the Ethics Code of 2021, for insurance providers under the IRDAI's guidelines, which were actually amended just last week. And last week's amendments require board level oversight on cybersecurity and privacy obligations of the company. If you are looking at an entity which is engaged in broadcasting, then the DOT and the TRAI impose specific obligations on data protection, data localization, and cybersecurity. Equally, if you are dealing with a company which is engaged in providing health services, whether it's a software company or a hospital, etc., then they are supposed to comply with the guidelines under the National Digital Health Mission. So in short, we need to look at not only the principal legislation governing data protection, but also the relevant applicable sectoral regulations. These apply in tandem and not in, they apply equally in addition to the DPDPA. We now will address some key terms under the DPDPA. Digital personal data is any personal data that is available in a digital form. The DPDPA only governs digital personal data. So we need to understand when personal data becomes digital personal data. If I am arriving at your office and I'm signing a register to gain entry into your office, that is physical data. But assuming that that register is later digitized and stored in our records, and that also becomes digital personal data that we are responsible for ensuring security of. So we need to very, very carefully assess all the points at which we are collecting data in a company. A data principal is simply the individual to whom the personal data relates. Can we go back to the previous slide, please? Yeah. Data fiduciary is the entity which is making the decision in respect of the data that is being collected. A consent manager is a completely new role. A consent manager will basically act as an intermediary between the person whose data is being collected, which is the data principal, and the data fiduciary who is making the choice to process that particular data in a certain way. In respect of portfolio companies, they may be a data fiduciary, a data processor, or sometimes both. We'll discuss how these roles can coexist in the next slide. And we'll also discuss processing and what that means in the next slide. Can we move on? Right. So why it's important to understand whether we are a data fiduciary or a data processor or both in a certain case is because the scope and application of the DPDPA is very wide. It applies to processing activities, and processing is defined as a very wide term. The definition is on screen, but essentially the definition is so wide that any action you can take in respect of personal data will amount to processing, because making available, simply viewing, restricting, even erasing is a processing action. The Act applies in respect of any processing in respect of personal data which is conducted within India. So it applies to companies which are operating within India, whether or not they are providing services to Indians or citizens outside India. And it also applies to activities, business activities which are conducted outside India, except where the processing is happening within India. So even in a situation where your service provider and the end client are both located outside India, but your company is appointing a service provider in India to conduct some processing activities, the DPDPA will apply. Can we move on to the next slide? Now, before we move on to understanding when and how you become a processor or a fiduciary in terms of the DPDPA, because that will need to be discussed in detail, I'll just quickly run you through the timelines of compliance under the DPDP Act. The regulator is also aware that the compliances are so nuanced that a 2-year period has been granted under the DPDPA to ensure complete compliance. In November of 2025, the operational provisions came into force. By the end of November 2026, the consent manager framework will come into force, and the powers of the Data Protection Board will come into force. Why this is important for the audience today is because consent manager is a completely new role, as I said earlier, and a lot of startups are looking to register themselves as consent managers. A consent manager will be responsible for speaking to the data fiduciaries on behalf of the data principal. Since this is a completely new role, the penalties are significant, but the application is yet to be tested. And by May of 2027, the entire act comes into force, which is where the responsibilities of the data fiduciaries and the data processors arise. So by May of 2027, you need to be in a position that all notice, consent, and duties and obligations are in place. The board is completely up to date on how the company intends to address any breach reporting requirements, any rights that the data principal intends to exercise in respect of their personal data, any duties that the processor has in respect of personal data. All this should be in place by May of 2027. Can we move on? Now, the DPDPA assumes that consent is a continuous cycle. So in respect of every activity that you intend to use any individual's personal data for, the Ministry of Information and Technology has provided a suggestion in respect of how that consent can be managed.
Bharucha, sorry, I think Ekta has raised her hand. Can we just...
Yes, of course, Ekta.
Sorry, I know you wanted it to be interactive, so just
No
jumping
worries.
in with a question to keep things interesting.
Yes.
Thank you. This is super helpful. My question was, so with regards to your last slide, you mentioned that May 2027 is when, the final timeline on the screen. So am I right in understanding that that's when all organizations, large or small, are expected to have this data protection framework in place? Because I do know that when it was first reported in the press, there was some conversation about larger organizations expected to do this first than SMEs, etc. So are we saying that May 2027 is when everyone is expected to have this framework in place?
Correct. May 2027 is the final deadline for all entities, big or small, to ensure compliance. We will discuss entities that may be processing larger quantities of personal data, which are significant data fiduciaries. They have additional obligations, but the timeline remains the same. They are also required to comply by May 2027.
Sure, thank you.
Right. So consent is a continuous life cycle. You collect it, you ensure that the consent you collected is valid for the purpose for which you collected. You update it if there is an update in the information of the provider. You renew it periodically to make sure that it is in place as and when you need it. And if it is withdrawn, you delete that information. And if you still need that information, you re-obtain consent. This is largely the consent management system that all portfolio companies need to have in place. I know the diagram looks very simple, but this requires very, very significant overhaul of your company's technical infrastructure, because you need to be able to identify what information relates to what person in real time and be able to take action in respect of that information, which is also why a 2-year timeline has been provided to comply with the DPDPA, because the obligations are extremely, extremely specific and onerous. Next slide, please. Right. So now we'll discuss what a significant data fiduciary is. As I was saying earlier, there may be a situation where you are both a fiduciary and a processor in respect of different types of data. We can address this with an example. If I am a software as a service provider to a hospital located in India, then the SaaS provider will, in respect of the hospital data, be a data processor, because the hospital is ultimately determining the purpose for which a patient's information is collected and is processed, etc., etc. So it becomes the hospital's duty to ensure that all the obligations under the DPDPA are being followed. Importantly, all the penalties are only on the fiduciary and not the processor. The processor in this case, which is the SaaS company, their only obligation is to ensure that all their actions are in compliance, in very, very strict compliance, and only within the limits of what the hospital has instructed them to do. So if you are dealing with only a data processor, it is a relatively lower risk situation, because then your focus should be ensuring that all your contractual liabilities and indemnities are in place and your actions are strictly in compliance with what has been instructed. If you are dealing with a processor, the risk exposure is very, very significant. It is even more significant if you are dealing with a fiduciary, which is a significant data fiduciary. A significant data fiduciary is an entity which processes such high volumes of data, which is sensitive data, that they may be designated as such by the government. As on date, no entity has been designated as a significant data fiduciary. But based on educated assumptions, we can assume that any fintech company, health tech companies, insurance companies, OTT broadcasters, any such nature of entity which is dealing with a very, very high volume of data, which is also sensitive in nature, might be designated as a significant data fiduciary. Why this is very relevant for anyone on a board is because the data protection officer such a company appoints is supposed to be located in India, and B, that officer is supposed to report directly to the board. So the DPDPA itself requires direct board level oversight on the data operations of any entity which is designated as a significant data fiduciary. In addition to, can we go back? In addition to the local DPO requirement, a significant data fiduciary is also required to conduct data protection impact assessments and periodic audits. Sorry, does someone have a question? A significant data fiduciary is supposed to conduct independent data audits and data protection impact assessments, and these should be line items in your budget. As I was saying earlier, the IRDAI has also just last week introduced cybersecurity guidelines, and even those require board level oversight. So as Vandana said in her introduction, these are not merely compliance requirements. The law is clear that the board needs to be on track with everything that the company is doing, because the queries and the imposition of penalties are based on demonstrated compliance. It is not necessary that a penalty will be imposed in every case. What the board needs to establish is that the company took all steps to ensure complete compliance with the applicable law. Can we move on? There are certain exemptions.
I had a question, Karnika.
Yes, of course.
So two questions actually. Section 8 companies which are not for profit, do they also fall under this ambit?
Yes.
They do? Okay.
Yeah.
And second is, if the DR site stores your data outside India, is there a concern around that, or have they addressed it specifically?
Okay, that's a very interesting question, actually. So the DPDPA itself allows data to be stored outside India, except for certain countries which the government may notify that you can't send data to. As on date, there's no such notification. But as I said earlier, there are horizontal regulations. So for example, if you're dealing with financial data, then RBI regulations require you to store financial data locally. So we need to, the DPDPA itself doesn't impose any obligation on data being stored inside India or outside India, as long as you take consent from the data principal to circulate the data outside India. But if sectoral regulations apply, then there may be a requirement for you to store that specific set of data within India.
Understood. Thank you, Karnika.
Nice. With respect to your question on whether Section 8 companies are also required to comply, any nature of entity, it doesn't even have to be a company, even a partnership, which is collecting a third party's personal data, is falling within the ambit of the DPDPA.
So this
Uh,
third-party personal data, so when you are doing not B2C sales, but you are doing B2B sales, there's obviously some individual who would be signing the order, say a CFO or something. So those, do they also fall under DPDPA, or only if I'm selling to kind of, individual customers like you and me, it falls under that perspective?
It also the previous case also falls within the ambit of the DPDP. Essentially, any situation where you are collecting an individual's data, that individual may also be an employee of your own company. So if you're collecting an employee's personal data, then you are falling within the ambit of the DPDP.
Okay, thanks.
With respect to employment specifically, I must highlight that the DPDPA sets out certain exceptions. Data that you generally need in the course of employment to, be able to pay out PF, etc., is exempt from all the obligations. But any additional data that you may take from an employee for any reason falls within the ambit of the DPDPA. There's also, sorry?
Biometric?
Yeah, biometric information definitely falls within the ambit of the DPDPA. That may also amount to sensitive personal information. So we'll also, depending on the nature of the data we are collecting, the Aadhaar Act may apply, DPDPA may apply, depending on the nature of the business that you're, the purpose of the collection of information. Some other law may also apply. Now, in respect of transactions specifically, there is an exemption under the DPDPA for pre-approved transactions. In those cases, you do not need prior consent. But if you look at the last line on the slide which is being presented, the exemption only applies in respect of pre-approved transactions, which means that even if you are looking at conducting a DD on a company for potential investment, to the extent that investment does not need prior government consent, you will need to ensure that you have consent to process that data also, which is why we are highlighting that this becomes a big governance issue. You need to ensure that even at the time of collecting consent in the first instance, where the company is not looking for any investment, the privacy notice that we present to an end client must in fact include a potential investment we might be looking at 5 or 7 years down the line, to ensure that we don't have to 7 years later go back to the data principal and collect their consent, because the data principal may not be available or they may not want to give you consent. And just to ensure that business continues, at the very first instance, you must look at every possible reason you might need to use that data and collect consent accordingly. Next slide, please. Now, the penalties for breach under the DPDPA are very, very significant. There is thankfully no jail term, but the penalty may extend to 250 crores. We need to impress upon ourselves that the penalty is 250 crores per breach and not per company. So if there are 7 instances of breach, the 250 crore penalty may apply in respect of each breach. But as I was saying earlier, the law does not assume that breach will never happen. So what we need to demonstrate is an effort to ensure absolute compliance, because what the Data Protection Board will look at when they are determining the penalty is what actions you took, what policies are in place, what was the nature of consent you took, how soon did you report the breach, etc. Based on your conduct, the penalty will be determined. So we need to exhibit meaningful compliance is the idea here. You will also notice that there are no direct penalties applicable on a data processor. So what this will practically lead to is data fiduciaries who are dealing with data processors, they will try to impose equivalent indemnities under the service contracts. So based on whether we are dealing with a data processor or a fiduciary, we need to look at contractual obligations versus demonstrated compliance. Next slide, please. So as I've been repeating, the legislation is horizontal. While the DPDPA itself does not prescribe a jail term, we also need to look at the Information Technology Act of 2000. A data leak may, depending on the nature of the event that has happened, may also amount to a cybersecurity breach in terms of the IT Act. If that is the case, then the IT Act provides for payment of compensation to the person who has suffered such breach. The DPDPA penalties are payable to the Data Protection Board and they go to the Fund of India. The IT Act provides for direct compensation payment to the person who has suffered a consequence of your breach. Importantly, the IT Act also provides for a jail term if the breach was conducted as a result of any dishonesty or fraudulent intent. And if such offense is committed by a company, then all the directors, managers, etc. of a company who were responsible at that time for the conduct of the company's business can be individually proceeded against. Ekta, do you have a question?
Yes, thank you, Karnika. My question was, given this kind of everything that you're sharing, I wonder what is in the best interest of a company. I would imagine, I mean, I work with an investment firm, not really with a business, but what do you think is the best way forward for a company to approach this at this stage while most businesses would be placed, kind of developing the architecture required to comply with this regulation? Is it wise to actually go to a tech provider, for example, to create this whole stack, or do you think like law firms should also be appointed? Because I do think there's, a lot of nuance that a lawyer can probably bring into this. This might be a good place for you to pitch in, do a plug also for the firm. But I just wonder who are the kind of key stakeholders. If one was to get this completely right. And just a follow-up question, because I need to drop in a few minutes, is like how robust or how comparable is the Indian legislation to other laws across the world? So, for example, EU has its GDPR. Do you think Indian regulation is more stringent or lax than them? Any views on that would be very valuable as well. But thank you.
Excellent. So I'll take the second question first. I personally believe that the DPDPA is more stringent than the GDPR, because even GDPR allows for certain exceptions which are not set out in the DPDPA for cases where you may process information without consent. The DPDPA provides you a very limited list of cases wherein you may process information without consent. The GDPR prescribes a more indicative list. For example, there is no exception even for news outlets to process personal data without consent, which is causing an uproar. And of course, people are approaching the court. But that sort of freedom is not in place in the DPDPA. As regards your first question, I think you need to speak to both a lawyer to be able to identify the sectoral legislation that applies to you, because a tech provider will not be able to do that. A tech provider will also not be able to identify the gaps you need to fill in order to comply with not only the DPDPA, but the IT Act and also the relevant sectoral regulation. But your lawyer needs to work in tandem with a tech provider, because the lawyer cannot solve for the individual obligations that you have in respect of ensuring data principal rights. So the short answer is you need to appoint both a tech provider and a lawyer, and they need to work in tandem with each other to ensure that you are compliant by 2027.
Thank you.
Right. Right. Can we move on to the next slide, please? So, because we discussed that the obligations are very, very significant, we've actually come up with a checklist for you to ask your portfolio companies before you proceed with any hiring of lawyers or tech providers, or both ideally. So step one is, and you can use this checklist as a sort of preliminary questionnaire you must ask your company or any portfolio company that you're dealing with. Step one is you map what kind of service provider you are. Are you a processor or a fiduciary or both? Step two is you assess your consent architecture. Are we even taking consent in the first place? If ideally yes, is it sufficient to meet the obligations under the DPDPA? And are we managing consent in such a way that we can actually enable people to exercise their rights in respect of that data? The third step is general obligations. The obligations set out under the DPDP are non-derogable, so you absolutely need to comply by 2027. As I said, it doesn't matter if you are a for-profit or not-for-profit entity, the obligations apply to you. So are there sufficient technical and organizational safeguards in place, which is where your lawyer and your tech provider need to come in and ensure complete compliance. One thing you will need to provide any service provider before they can advise you on compliance is a data flow diagram mapping all the nodes through which data comes into your company, which may include employee data, service provider data, vendor data, client data, end client of clients, their data which comes to you. All that needs to be mapped immediately. That is the only way in which any service provider can assist you with complying with the DPDP in effect. The next step is data principal rights operationalization, which essentially means, are you prepared? Are your IT systems capable of ensuring that you delete information and stop processing that relevant individual's information if they make a request in respect of their specific data? Or is it that you're dumping all data in one place, and when the request comes in, you are not able to identify which person this information relates to? Because the timelines for ensuring that the person is capable of exercising their rights are immediate. So it's not like we can request for a 4-week timeline to delete someone's information when they have asked us to delete it. Next slide, please. If you are designated as a significant data fiduciary, even before the designation comes into force, there must be some level of self-assessment because the obligations are that much higher. You are supposed to build line items in your budget. You are supposed to appoint a DPO which is resident in India. The board reporting format needs to be put in place. So I strongly suggest self-assessing yourself as a significant data fiduciary and taking all actions to comply. If your portfolio company is engaged in the processing of children's data, then that is a very, very high risk area because what the DPDPA requires you to do across the board, irrespective of the service that you're providing, except for some specific exemptions for hospitals, etc. But those are also very, very specific in nature. You are required to obtain parental consent for any person who is under 18 years of age. The parental consent need not only be obtained, but it has to be verifiable. So tomorrow, if there is an issue in respect of processing a child's data, you need to ensure that not only was parental consent taken, it was valid, which parent gave it, if there is no parent in the picture, which guardian gave it, which child it relates to, and whether we have enough technical systems in place to recognize that a child is coming onto our platform. Another important thing under the DPDPA is that it absolutely bars the behavioral monitoring of children, which affects your ads on any platform, because you if you are running, say, an OTT platform, you need to build a separate profile for children. If you are a gaming service provider, you need to build a separate profile for children and ensure that no behavioral tracking is taking place. The next step is vendor and data processor management. Assuming that you are say a SaaS provider, you may be identified only as a processor and not as a fiduciary. Then you really need to look at your contracts and ensure that contract all indemnities are in place and liabilities are limited. As a fiduciary, what you must understand in respect of your vendor contracts is that a contractual indemnity will not shift your regulatory liability. So even if you seek indemnity under a contract, your liability to the data protection board does not shift at all. Next slide, please. I think someone had a question earlier on cross-border data transfer, so we already addressed this. Then we have governance, board oversight, and training. As I said earlier, if you're a significant data fiduciary, the data protection rules specifically require board oversight. But as Vanna said in her introduction, generally, because the penalties are so high, there are impact assessment requirements, and the board must have complete oversight on the actions that a company has taken to ensure compliance. We have provided an indicative timeline of 3 months for covering gap assessment, around 4 to 6 months for design and consent UI redesign. This is the part where your lawyer and your tech provider need to work together. Covering gap assessment is the first step where you ask the questions. Where is that data coming from? Where is it going? Where is it being stored? You can ideally make a flow chart and give it to your lawyer. The lawyer can identify a relevant tech provider based on your needs, or you can suggest a tech provider. They can work together. And by month 7 to 12, you should be at a position where you are working on system implementation. Thereafter, you can achieve any independent audits and board certifications and ISO certifications and anything else that you can think of or is required in the DPDP or applicable regulatory requirements to ensure that you can demonstrate compliance. Again, I must repeat that for risk modeling, the penalty for under the DPDPA is per incident, it is not per company. So it is very infrequent that a data breach occurs and only one data principal's information is leaked. Generally, when you look at a breach, it will be a breach where multiple data principals will be affected. Each data principal being affected will be treated as a individual breach. Next slide, please. We now have some case studies. Do we have time, Prerna?
Yes, we have a time, please.
Excellent. So this is a situation where you have a service which provides prepaid wallets and savings products for children. Now, because a child is a very sensitive category of person in terms of the DPDPA, the first thing we need to ensure is that our platform has appropriate age gating mechanisms and parental onboarding mechanisms. That is step one. You, in any case, have to ensure that the manner in which the child finds out about your platform is not through behavioral tracking or monitoring. The next step is to obtain that parent's verifiable consent before activation. How consent can be verifiable is something you'll have to speak to your lawyer and your tech provider about, because the more data you collect about the parent, the more your obligation also increases. Equally, you can't collect only the parent's name and say that that is verifiable consent. You also need to disable completely any behavioral tracking or profiling or targeted advertising for children. You need to provide a dashboard for the parents to monitor the transactions. Now, this is a suggestion. It is not a requirement under the DPDPA, but this will significantly reduce your liability. If you are automatically providing a platform where the parent can log in and assess what their child is up to, and have toggles for the parents to limit access control, then that puts you in a very good situation. And if there is a breach which happens and you are before the data protection board. Of course, because this might include financial data, you will also have to follow the local storage guidelines. Next slide, please. Here we have taken the example of an ed tech platform which is handling both Indian and foreign data. So when we spoke about applicability, we discussed that to the extent that any processing is happening in India, the DPDPA will apply. So even if you are an American platform providing services to children located in, say, France, but your processing is happening in India, then the DPDPA will apply. But again, the primary liability will be on the platform which is located in America. So what the Indian processor needs to ensure is that all their agreements are in place. And all the liabilities are clearly discussed, and the processor is only working strictly in accordance with what the instruction is. You need to have reasonable security measures in place, of course. You also should, if you are dealing with sensitive categories of data like children's data or health data, we strongly recommend whether or not you are a significant data fiduciary, you should carry out impact assessments for any high-risk data activities, especially before implementing a new tool on an existing platform. What this does is, A, it's very good practice, but B, it helps you build a case before the data protection board to say that, look, we took all reasonable steps to ensure that no leak happens. And after that, you, of course, can't avoid a leak in a tech environment. So it just puts you in a better position. With respect to parental consent, again, the same as the previous example, it needs to be verifiable. But we also need to ensure that we are not collecting unnecessary information that may harm us later. So maybe don't collect Aadhaar cards of parents to ensure that they are parents of the children, because then you have additional responsibilities under the Aadhaar Act. If you are a significant data fiduciary, again, you need to appoint a local data protection officer. Even in other cases, while the Act does not specifically mention the word data protection officer, you do need to appoint a person to deal with the board. We recommend generally that every nature of entity to whom the DPDP applies appoint a data protection officer. The only delta being that if you are a significant data fiduciary, that officer needs to be sitting in India. One very important thing when dealing with children's data specifically is that you should limit data collection to what you strictly need. So, for example, I was speaking to a tech service provider earlier this week, and what they told me is that they are collecting some information, including gender information, in respect of on their service, which is assisting with hiring of candidates. And I had a natural question, which was, are you using that gender information to make any decision in respect of the hiring? And they said, no, it's just the default question we ask. And then what was highlighted is that if we don't need gender information and we are collecting it anyway, we are exposing ourselves to an unnecessary risk, including, being subject to the Trans Rights Act, which prohibits using gender information to make any decision in respect of employment of a person. So what we really need to look at is, are we collecting information that we need, or are we collecting information that is ordinarily collected? The more we limit the information that we are collecting, the safer we are in terms of the DPDP, and we can accordingly manage liabilities. Equally, you need to delete what is no longer necessary. In respect of some sectors, the DPDPA or other sectoral regulations provide a particular time period. For example, for gaming and social media, I believe the time period is 2 years. After 2 years of inactivity, you are required to delete a profile. But that may not work for a edtech provider, who's dealing with children in the 5th grade, because you may need to store that information until they are out of school or even later. So you need to assess personally whether you need to store personal information for X period, Y period, obtain consent for that period. If you intend to retain information after that period for, say, analysis purposes, what you can consider is anonymizing that information, because you may not need a student's name to analyze their results 10 years down the line. These systems need to be in place well before 2027. Next slide, please.
Kanika,
Yes.
yeah, and I think this is a truly useful session. So I'm just going to jump in for a quick poll. So we would love to hear your feedback. So it will help us to make future sessions more relevant and impactful. So can I launch the poll? I will
Yes,
just
of
take
course.
2 minutes, please. Yeah. Thank you for your responses. The poll is now closed. So Kanika, you can continue, please.
Thank you. To Fauzia's question, Fauzia, not necessarily. If a listed company has appointed a DPO and the roles and obligations of that DPO also extend to ensuring compliance of the subsidiaries, then you don't need to appoint another data protection officer. But equally, if the roles and obligations do not cover the subsidiaries, then you need to appoint a DPO in each subsidiary. Again, the DPO designation is only for significant data fiduciaries, but we do recommend that you appoint some person and designate them as a data protection officer, because that is terminology that everyone understands, including data principals. And there's no recommended qualification as such for a DPO. So you can choose to appoint one DPO that looks over the entire the parent company and the subsidiaries, or you can choose to appoint individual DPOs across each subsidiary. That is completely a board decision. What I'm noticing in practice in larger companies is that one DPO is being appointed by the parent, and they are managing the overall consent architecture for all the subsidiaries also, to ensure that everything is working in a compliant fashion. I think someone had their hand up.
Yeah,
Yeah,
that'll be
Arpita.
me.
Yes.
So, a good question on with regards to SDFs and requirement for audits. Uh, if a company is a B2B, not an SDF yet, are we required to do certify, or how are we required to actually certify for internal audit committee, or how is that supposed to happen? That was one of the points that you mentioned on your checklist.
Yeah. So there is no legal requirement, there's no statutory requirement as such if you are not an SDF yet to conduct audits. But there are several service providers who are technical service providers who will actually conduct an internal. So, for example, even when you go to get an ISO certification, They will come to your office and do a full audit of your tech systems. And based on that audit, they will grant you ISO certification, ISO 27001, I mean. So while it is not a statutory requirement, one very good way to assess compliance gaps is to conduct an audit voluntarily to identify what are the pitfalls and where are the various nodes through which data leaks may happen. But it's not a statutory requirement as on date for any entity which is not in SDF, and no SDF has been notified by the government yet. Any other questions? I don't think so. Nandini, can we move on to the last slide, please? Right. So based on everything we've discussed, the key takeaways for anyone who's on a board is that are your consent mechanisms and notices in place? Again, this applies in respect of every company of any nature who is collecting personal data on any level. You can be a B2B concern, you can be a B2C concern. It doesn't matter. You may be engaged in a service that is ordinarily not even collecting a certain kind of data. Like insurance providers may be collecting personal data of children as beneficiaries. But even in that case, the obligations in respect of children data apply to you. So, as an insurance provider who is holding children's data, you need to ensure that no behavioral tracking can be traced back to you in respect of any ad for your product that a child has received, which is why consent mechanisms and notices are very, very important. It's also very important that your notices are exhaustive because, as I said, even in respect of mergers and transactions, the exemption is only for pre-approved transactions. So the day you are serving a consent notice or a privacy notice to a data principal, that you need to be absolutely sure and future proof that consent notice. Then you have the rights of data principals and organizational duties because the DPDPA grants certain rights to the data principals, which include right to access their data, up their data, and the right to request deletion of that data also. You must ensure that your portfolio companies are able to not only provide these rights theoretically, but their IT systems are actually capable of granting these rights within a reasonable time frame. We already discussed the significant financial penalties and the specific corporate governance requirements that are built into the law. The DPO is supposed to report to the board, and the penalty exposure is very high. I am again repeating that 250 crores is per incident and not per company. So we need to be very, very sure that we demonstrate compliance meaningfully. Again, if you are a significant data fiduciary, then you need to build budget line items in place to ensure that the annual impact assessments are happening and avoid triggering any regulatory scrutiny. One principal consideration for PVC firms is that your due diligence is not an exemption. So you need to have consents in place. This will obviously affect your portfolio valuations because the penalties are so significant, and even the compliance requirements will require a lot of money to be spent in terms of impact assessments, in terms of delivering notices even to each relevant data principal. And you need to have IT assets in place to ensure that the rights are exercised. If you have any questions, I'm very happy to take them now. Thank you. I hope the survey resulted in some good results.
Any questions, please?
No, I just want to give a feedback. It was really nice, Karnika, Vandana.
Thank you, Asha.
So yeah, because these are little new to me in my role, and I think very relevant points came up because we deal with a lot of people in my own capacity. I have a direct network of 4,000 people with me who we take data for attendance. And now I really need to go back and understand that what is my responsibility these are all third-party employees that we are employing and deploying at our cinemas. So I'll have to maybe go and find out a little more about it. I mean, I've understood some part of it, little technical at this stage, but
Asha, what you're saying is very important because even that data, if you're putting it into a computer system, that is data on which the act applies. So
So I actually, every time our auditors ask for it. I mean, I don't really need it. These are getting maintained at individual cinemas and which are under a security system under everything. But I need to know like what do we do with it once the agency changes or whatever. So I need to have some system in place where, we kind of put these registers away in a proper way. At this point of time, it was all like fine. But I think I just need to go back and reassure that things are safe at my cinemas.
exactly, you may even identify some data that doesn't need to be digitized at all. Maybe you
Yes.
can store
Yeah,
them
we
in
don't
registers.
want it because they're not our employees, but I
Exactly.
still want to protect it as being a principal employer, especially for the people who are not with us anymore. I think that is very, very relevant for me. So
Exactly,
thank you
because
so much.
there is also a requirement to delete data of those people.
Exactly, because that's what I'm saying, that till such point it was like, okay, we remove the registers, we park them in a space, but then what are we doing after a certain point? Where do they actually go? So do I need to kind of destruct them, physical evidence or whatever? We will have to go back to our DOP, like you said. We'll go and DPO. We'll go and find out. Yeah.
Thank you.
Thank you so much. I think very, very good for me.
Thank you. Arpita, you have a question?
Yeah, first of all, thank you for this informative session. I mean, it was really great because from a board level perspective, we are just trying to understand whether, the current notices that we have in place, which are globally aligned with respect to GDPR or let's say Brazilian acts. Uh, but as you said, DPDP is more stringent, right? So, is there also an expectation that we provide an appendix to the current notices related to DPDP, or make sure that it is fully in compliance with the, or prepare a separate kind of consent notice for DPDP so that it's in compliance with the act. I
That's
mean,
a great
how?
question, Arpita, and
Yeah.
my answer, unfortunately, will really anger you. But what the DPDPA requires you to do, even in respect of the consent you already hold, is to go back to that data principle and re-obtain that consent.
Yeah.
So necessarily, some parts of your consent notice will have to be updated because now the consent notices are supposed to contain the rights of the data principal and the manner in which they can report to the board. But not only do the notices have to be updated, they have to be resent to everyone whose data you are processing, and that consent has to be reobtained.
Got it. Got it. I think that's really helpful. And especially this is for the Indian citizens and not globally, right?
It may apply to citizens globally to the extent that your processing activities are happening in India, but
Okay.
that will need to be analyzed on a case to case basis.
Got it. Right. Helpful. Thank you.
Thank you.
Any other questions, please?
Just as a continuation of that previous question, if there is any frequency, like we need to take that consent?
So what we recommend is there is no frequency in which you need to take consent, but the consent needs to be purpose specific. So for example, if I have taken my client's consent to process their information for the purpose of providing legal services, and tomorrow I need to use that data to market myself in a different market, and I don't have that consent built into my fee proposal, then I will need to go back to that person and re-obtain consent for that new purpose, which is why we are highlighting that the minute you are implementing a consent notice, it needs to be future proof also. Because it's simply not practical for you to keep going back to a data principle and obtaining consent for new purposes. So you need to sit down with your business team, analyze all potential purposes, including potential investment 5-10 years down the line, in respect of which you may need to use that data and take consent for that specific purpose today.
Okay, thank you.
Any other questions?
No, I don't think so, Karnika. Thank you so much for your time.
Thank
On the
you.
behalf of Winpe WB, I would like to extend a heartfelt thank you to all of you for joining us today and making this session so engaging. A special thank you to our faculty, Vanna and Karnika, for decoding the DPDP Act and helping us just to understand the nuisance from a board level perspective. So I'm sure all of us feel more confident in reviewing the implementation of this act across the companies. So thank you so much once again and look forward to seeing you again at another WB initiative.
Thank you, Prima.
everyone.